negotiated settlements, obtained injunctions and money damages, and essentially dealt with the entire matter from a civil perspective. Now, while doing this civilly, we also decided that we wanted to bring this to the attention of the government and try to persuade the government to criminally prosecute those responsible. We had collected so much information that, as a result of the civil action, that we were able to package it up, ferret out what was important, put it in notebooks, essentially tie a ribbon around it, and bring it to the federal prosecutors and federal government investigators, and presented the case to them in a way which would allow them to then conduct their own independent investigation and determine what action, if any, to take from a criminal standpoint. So in this one case alone, we partnered with our own private investigators, with foreign counsel, with government investigators, government prosecutors, both at the federal and state level. We also dealt with confidential sources who presented themselves and essentially offered to provide information to us, and that was helpful as well. And they do show up in many counterfeiting investigations. Now let's focus a little bit on the use of private investigators. It's necessary to work closely with private investigators in counterfeiting cases. They investigate the counterfeits, they make buys, they follow the money, they follow the communications, they collect information about the counterfeiters, and they help us prepare cases civilly and can help us and help the government eventually prepare a case criminally. How do private investigators do this? And is what they do legal and ethical? And what do we lawyers need to worry about? And that's lawyers who are outside counsel and in-house counsel. The way private investigators do this, or one way they do it, is through pretext investigations. Now, pretext investigations received a lot of publicity a couple of years ago in the wake of the Hewlett-Packard scandal, because pretext investigations were used there. In the Hewlett-Packard situation, Hewlett-Packard was trying to find the source of leaks, and they had investigators who pretended to be John Doe to get information about John Doe. That's not what we're talking about in trademark counterfeiting cases. What we're talking about are investigators who pretend to be counterfeiters, they pretend to be consumers, they go and they speak to people, they do it through the internet, they do it by telephone, they do it in person. And how do they do it? They use deceit, fraud, misrepresentations, all the types of things that lawyers cannot do directly or indirectly. Now, California proposed legislation to bar pretext investigations. It would prohibit any person from, among other things, obtaining disclosure of information about a customer or employee located in the business records by making false or fictitious or fraudulent statements or representations. And any information contained therein that the investigators were to collect and use would be inadmissible, and those folks involved would be subject to civil penalties. The proposed legislation in California exempted law enforcement, but not private investigations. This was a major problem. It would be a major problem if that law were enacted, because pretext investigations are so important in fighting counterfeiting. Now, there is no law that I'm aware of that prohibits it, but let's turn for a moment to what's ethical for lawyers. Lawyers generally cannot conduct or supervise somebody else in conducting